Well, hello Richard, it's nice to
Jamie.
see you again. And today we're going to be talking about a new case, or a recent case that the CMA has just launched against V4, where the theory of harm is that V4, a pharmaceutical company, has abused or may have abused its dominant position by disparaging a competitor's product. And the products in question here are intravenous iron deficiency treatments.
Yep.
So I thought maybe we could just kick off. As the first standalone disparagement case in the UK, what does a disparagement case look like? What's the CMA looking at?
Yes, okay. Well, I mean, as you say, it's the first time in the UK we've done precisely this. There have been disparagement cases around the EU. And the essence of the idea is this. I have a product. It may be pharmaceutical. It could be something quite different. There are competitors trying to compete with me, and of course there are various things I could do to try to exclude them. I could discriminate, I could predate, blah, blah, blah. But one thing I could do is to go to the customers of the product in question and say, you do know that my competitors' products are dangerous, unsuitable, unfit, untested. I could disparage my competitors' products. And then the issue that arises there is, can that infringe competition law? And in particular, if I'm dominant, is this an abusive act because it's an attempt to exclude my competitor? It's a very fascinating idea.
Certainly is, and it does seem to me that you mentioned some of the cases, quite often as pharmaceutical cases, where one can imagine that things like safety and whether or not a competing product is safe would have a real impact. But there are cases in other sectors.
Well, look, I mean, you can clearly see how it can happen with pharmaceuticals because you've got a very specialised community. There's me, the pharma company, there's a competing pharma company, there is a consuming market out there, which is doctors and consultants and specialists. And so I do have real opportunities to say to the experts, you do realise that's an unsafe product. But does it only happen with pharmaceuticals? I've got here a piece on disparagement cases around the EU. This was produced by PAR in June of 2022, where they look across the ECN and they say, well, of course, there's the taxi drivers boycott case in Catalonia, there's the dental associations in Spain, there's the ambulance services in Denmark, there's DTT broadcasting in France, there's even Caribbean yogurt done in France, it's a Parpemont in the Caribbean. So it's by no means only pharmaceuticals.
It's very interesting. I mean, even the Danish ambulances one feels like it's at least operating in a sort of similar sphere. Of where
Yes, but some of these are definitely not in that sphere.
Caribbean yogurt's one I don't think I was aware of.
Quite.
One of the things I thought we should talk about is when we're talking about disparagement, the cases are often focused on disparagement that is misleading, saying things are not safe when in fact they are. There must be a difficulty for dominant companies when they have strong views about competing products to tread a line between what would be anti-competitive disparagement and their fair comment on the pros and cons of their product versus someone else's.
Well, I'm sure there's always a fine line between breaking the law and not breaking it, but what we're saying here is be very careful.
It's always good advice, being very careful. Now, this is a case that the CMA has opened a case, but the European Commission's also got a case with the same company, V4, at its heart. Yes. And I wondered if there's any lessons that we should be taking from the fact that here's a case, it seems like very similar facts, and we've got a European case and a CMA case.
Well, look, two things I would say there, Jamie. First of all, the Commission, I know, has got two cases, and they've opened one against Teva.
Yes.
And in the case of Teva, they're saying, firstly, we believe that they have misused regulatory procedures. That's a bit like the old AstraZeneca case. But also we think there's disparagement. It was reported, I think it was in June of 2022, that the Commission was conducting a disparagement case against V4. I don't know, but one assumes that maybe in relation to the same subject matter as the CMA investigation. So obviously there is the question here, are the CMA working with DG Comp? What's going on? I do not know the answer to that. it's a statement of the obvious to say that we are no longer in the EU, therefore we're not in the ECN, therefore we don't have access to the same evidence that NCAs have of each other. But I don't know whether and to what extent there's cooperation going on there.
I suppose the other thing that comes around as a post-Brexit matter is it wouldn't be impossible for the CMA and the Commission to take quite different approaches on these things. Now that the CMA is not bound by the practices of the European Commission on this.
Well, I agree. I mean, in no sense are we bound by any EU law here. Indeed, there isn't any EU law to be bound by at this stage, quite apart from Brexit. But I wouldn't expect the CMA and DG Comp to diverge on this issue particularly. I've got no doubt in my own mind that disparaging a competitor's product when I'm dominant, I don't see the slightest difficulty in seeing that that can be abusive. Now, of course, it may be that the same behaviour is also tortious or delictual, because there's a tort of injurious falsehood, and in continental systems there's unfair competition, and this may well be unfair competition. But the fact that it violates another legal norm, does that mean it can't also be abusive? I can't see any reason why not. And if you think back to AstraZeneca, AstraZeneca is found guilty of basically misleading patent offices and thereby getting an extension of their patents. Well, misleading patent offices is an offence under the relevant patent law of Denmark or Belgium or Sweden. Fair enough, but that doesn't mean that the same conduct can't also be an abuse of a dominant position.
Quite. I suppose the other thing that's sort of related to that is what modes of redress do you have if you're the competitor, the upset competitor here who's had their products disparaged?
Well, that's easy, isn't it? Damages.
Well,
and or an injunction. Stop doing it and pay me for the business I've lost.
And what we have, of course, in the UK is that the competitor did start a claim in the High Court. And so we've got some High Court litigation potentially. I'm not quite sure exactly where that's got to. And a CMA investigation.
Yes.
It's interesting when you've got both of those running at the same time.
Well, let's face it, there's plenty of examples of that nowadays. Forget pharmaceuticals, let's think about digital platforms. CMA's got cases against Apple and Google, and at the same time you've got actions in the Competition Appeal Tribunal. So having parallel public and private enforcement isn't a new phenomenon at all.
Potentially not completely new. Going back a few years, you'd have seen a lot less of it, I think.
Well, several years ago, the world was a much less litigious place than it is now. I mean, I'm absolutely astonished, frankly, at the amount of B2B litigation that there is in competition law nowadays.
Quite.